Hey there, so in this video we're going to talk about where you should store your last will and testament. I'm Paul Rabelais, I'm an estate planning attorney. Asked quite a bit, Paul, where should we keep our last will and testament? And it's an important question because when somebody passes away, people need to have access to the will. The right people need to have access because it needs to be one of the first things that happens, it gets filed in the succession or probate proceeding to start the succession, perhaps get the executor confirmed by a judge, and then ultimately at the end have a judge order the disposition of the assets to the heirs that are named in the will. So it's really critical that the original can be located easily after somebody passes away. A lot of different options there on where to keep it. Let's talk through a few of them. First one is some people say, well, we did a will 40 years ago. I guess it was filed at the courthouse. At least here in Louisiana, wills don't get filed at the courthouse until after somebody passes away, when that, court proceeding gets started. Can't start the court proceeding, that succession or probate proceeding, that court-supervised process of getting everything transferred to the heirs. Can't start that until after somebody passes away. So wills typically aren't filed at the courthouse, while the person who wrote the will is still living. Some people say, well, Paul, I'll tell you what, let's just, we'll keep our will at our home. Another alternative there. The advantages of that are the will is easily accessible by the surviving family members. When somebody passes away, the will's right there, perhaps on the shelf in the home. And so you can take a look at it if you need to, if you're wondering whether things should be changed or updated, it's all right there. Disadvantages, particularly in the last few years in Louisiana, we had a little hurricane called Katrina, and boy, did that wipe out some people's wills. Wills went off, floating into the water. We had a flood in Baton Rouge a couple of years ago, 2016. Wills floated away. Wills were gone. And when that's the case, it's back to a situation where the person's deemed to have died intestate or without a will, which could be very different results from what you provided for in the will. So if you're going to keep it at home, make sure you keep it in a waterproof, fireproof safe, preferably one that's large enough or built into the structure so that theft is not an issue. Some people say, Paul, well, perhaps we should keep our will in our safe deposit box. Well, then if you do that, you've got to determine whether you're keeping it in a safe deposit box that no one has access to after you pass away, or someone has access to it when you pass away. If you put it in your safe deposit box and no one else has access to that box, then nobody's going to be able to get into that box to get your will after you pass away without some kind of court order, which is a bit of an inconvenience. So some people put their will in their safe deposit box and make sure that either their spouse or their trusted child or some other third person is listed as having access to the box, so when the person passes away, that other person can go to the bank and access that safe deposit box, retrieve the will. Some people, on the other hand, say we left our will with our attorney. That's another option. I've never been a big fan of leaving your will with your attorney because attorneys move all over the place. And so the will may not be accessible 10, 20, 30, 40 years after you wrote the will and somebody passes away. You may not be able to find that attorney. Another reason I'm not real crazy about the attorney keeping the will is when the attorney has the will and the person who wrote the will passes away, those surviving family members are really forced to go back to that lawyer, back to that law firm, back to that attorney's office and say, our spouse, our husband, our wife, our father, our mother passed away, you have the will, we need it. Kind of puts the surviving family members in a scenario where they feel obliged to have to use the attorney for all of those probate services. And being an attorney, I know that kind of a lot of attorneys, use that as a business advantage to them. Well, hey, I'm going to keep the will, and the real money is when not in the preparation of the will, but the real money is in the probate. I'm going to keep the will, so the family's going to have to come back to me. And it puts everybody in an awkward situation if, when the person dies, the surviving family members don't want to use the services of that particular attorney or law firm that's in possession of the will. So, maybe not the best place there either. Louisiana, we have something that I don't see used very often. It's called a will registration form, and it's issued by the Louisiana Secretary of State. And here's a copy of Louisiana's will registration form that the Secretary of State has. Here's the way it works. It says, file this original will registration form and the filing fee of $10 with the Secretary of State. It says in big, bold, capital letters, do not enclose a copy or the actual will. So really, this is something maintained by the Secretary of State, and it just really talks about the existence of the will and where that will might be. So the information that one provides to the Secretary of State is your name, your address, your social security number or other identifying number, your birth date, where you were born, and then you can fill in those lines toward the bottom. You can write in the intended place of deposit or safekeeping of the instrument, or the name and address of the attorney or other person having information regarding the place of deposit or safekeeping of the instrument. So then the idea is, after you pass away, your survivors can go to the Secretary of State. Secretary of State won't release any information until a valid death certificate is provided to the Secretary of State, along with a fee of $10, and then they'll release the information that's on here to that survivor. So don't really see people using this very much, but it's another option out there if you want to document where you intend to keep your will and you want to document that with the Secretary of State's office. That's available. Bottom line here is, store your will in a safe place. Let those those individual or individuals that you trust to handle that when you pass away. Let them know of its existence and its location so they can take care of your business after you pass away. And so just explore all those different options that you have. Keep it in the right place and let those trusted people know of its existence and location. Hope that helps. I'm Paul Rabelais. Go out and have a great day.